Hello, everyone. Bonsoir. Good evening. And thank you so much for joining us. I'd like to start by recognizing that Manitoba Music is a settler organization based on Treaty 1 territory, the original lands of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene people, and on the homeland of the Métis Nation. I'd also like to recognize the strong Inuit community here in Manitoba. My name is Ashley Bianyaj, and I am the Indigenous Music Development Coordinator at Manitoba Music. Today, we're joined with Mike Duboff and Bert Jadaro from Edwards Creative Law. This is the final session of the On Track Indigenous Music Business Basics series that's happening this month, or happens this month, that was streamed to Facebook and to YouTube. These are sessions that talk about foundational business skills, helping artists like you get organized and develop the tools needed to establish your music as a business. Today, we are talking about music law and agreements. If you want more information on the On Track series, you can go to indigenousmusic.ca/ontrack. If you have any questions during the presentation, please leave them in the comments, and I'll be sure to ask Michael and Bert during the presentation. And with that, hello, Mike and Bert, how are you?
Doing well. Thanks for having us here, Ashley.
Thank you so much.
Ashley.
If you could introduce yourself and say kind of what you do at Edwards Creative Law, and then can get started with your presentation.
Sure. And am I sharing the screen already? We've got a bit of a PowerPoint ready to go.
Yeah, do you want to introduce yourself first, and then I can pop it up?
We have some slides that kind of tie into
kidding.
the introduction.
Sure. Okay, here we go.
So myself and Bert work at a firm called Edwards Creative Law. The firm is headed in Ottawa, but we're recently expanding. So we now have offices in Toronto as well as in Winnipeg. We're a fairly full-service entertainment law firm. We focus in music of all types. We work with performers, writers, managers, producers, companies, and festivals, all of whom we have as clients. As well, we do a lot of work in film, television, interactive digital media, and some other kind of newer forms. So we work with some influencers and social media groups and some esports as well. And so we're across the board in terms of the entertainment industry. With regards to myself and Bert, we both actually come from a musical background. As you can see, Bert is quite qualified and experienced in the industry. He's been with a lot of different organizations across the years and on a number of boards. I am born and raised in Winnipeg. I'm a Winnipeg boy. I still spend about half my time there, so I do a lot of our Winnipeg work for the firm there. And I'm now part of Manitoba Music, as well as On Screen Manitoba and Manitoba Film and Music. So between Bert and myself, we have quite a number of years of experience in the entertainment industry, both as a lawyer and as a musician. And so today, as your final session, we're going to try to keep or make entertainment law and agreements as exciting as possible as your final session. So we're going to be covering a lot of different types of agreements across the board that have to do with co-writing, working with producers and managers, agreements within bands between the artists, with show and performance agreements, as well as record label agreements. So really any type of work that's done in the music industry, you will often find agreements that kind of tie into that area. And so we're going to kind of try to touch upon all of these a little bit with a focus on, especially on the co-writer agreement, the producer agreement, and the manager agreement. So Bert, if you want to step in to kind of introduce music law a bit.
Yeah, for sure. I'd love to give you some background on that. So, these are the very preliminary points in music agreements, and they're rooted in contract law. And so what makes an agreement legally enforceable? Basically, we're talking about there's offer and there's acceptance. And the next point sort of addresses the fact that you can have offer and acceptance in a number of forms. And so it could be verbal or oral, meaning, somebody says, hey, I'd like to buy your lawnmower for $15, and you agree, okay, well, that's what you can pay for it. We have a deal. that's a contract. That's an agreement. You've agreed to do that. It doesn't need to be in writing, and that would end up being enforceable in a court too, although you're not likely going to go to court over a $15 lawnmower. So what does planning for success have to do with it? Got to do with it, I guess that's the Tina Turner way to say it. And it has pretty much everything. So just in terms of music agreements, that's really the plan. And in a lot of ways, it's the rules between you and that other party in terms of who's going to get paid what, who's going to do what, who's going to deliver what. And so the next point is it too late to get this in writing? And typically no. Like even if you've made a deal that's oral or verbal, you're going to want to write that down. And it might be enforceable before that fact, but at least in putting it on.
Oh, we've lost Bert. I don't think he's coming
So
back.
they don't remember that they
he's back.
agreed to do something.
Sorry, Bert, would you be able to repeat that? We lost you for a second there.
Sorry about that. I will try and deal with it, but it's I'm trying to remember here. If people sometimes have selective memory, and I'm just going to switch over. Mike, could you take over for a quick second? I'm going to switch my internet here.
Yeah, sure thing.
Thank you.
So I'll just go back a quick moment to I think where Bert left off. So what it comes down to is a lot of the points that we're going to be talking on tonight really deals with planning for success. So these agreements are in place to really protect you as an artist and then ensure that the pieces are in place for you to be able to capitalize on the music you're making, both monetarily and in other ways as well. So these agreements are to set out different relationships between you and other parties and people that you might come into contact with as a musician. And so as you can see here, it's never too late to get an agreement in writing. As Bert kind of said, you can have agreements that are both in writing, which are the ones we see often, as well as verbal ones that can later be turned into paper agreements. And so what music lawyers will do is they'll help you to understand these agreements that are proposed to you or that you might propose to another party. We'll be there to kind of talk you through the terms, make sure that you're protected, and we're there just to be your kind of guidance as you kind of enter into these relationships. And so the three kind of ways that you can monetize your music later on are through different royalty avenues. And so that's writing, which is, as you can imagine, that's the composition of a song. There's the master, which is the form that it's recorded in, and there's the performance royalty, which is getting money from your music being played in different forms. So it could be over the radio, it could be on Spotify, or it could be on YouTube, and kind of avenues like that. Exactly. Bert, we have you back?
We do. I think I'm on something a little bit more reliable right now. So so I'm ready to continue, but I think maybe we can talk about. Why don't you continue, Mike?
Sure. So what's important is to know who you're signing an agreement with. So this is part of what a music lawyer or an entertainment lawyer will do for you is the due diligence. So that's understanding who the other party is and doing a bit of research to understand that it's the right partner that you're dealing with, it's the right time to be entering into this agreement, and it's the right project to be working with them for. So all these things kind of tap into planning for success, like we said, and what a music lawyer can help you with. And so it's really understanding just the kind of agreement that you're getting into and doing a little bit of work to making sure that it's the right opportunity and right person for you. And as you can see, there's some challenges that will come as you enter into an agreement. So again, a music lawyer can help you understand these facets, which there's sometimes inconsistencies between what's said by the two parties, making sure that you're on the same page. And so there aren't difficulties or disagreements later on. Similarly, there might be a lack of clarity in what one party is saying or what's actually written in an agreement that you might come across. And so it's just doing the work, putting the little time into making sure that everything is lined up correctly for you. And so you need to have a little patience for these kinds of matters.
Right. And so if I can speak to that too, it's like like you said, it's extremely important to have the right party. Like, and that's the other person that you're working with, because if there's a trust level, not that you want to just let everything go, but that's going to help instruct the clarity, and it's going to give you the I was talking to a prospective client who was talking to someone who was he was looking at partnering with, and there were things that he was very he needed information, but it was too soon to share it with him, and we wondered about maybe having a non-disclosure agreement that would bind him, and he wouldn't be able to use that information. And then we sort of thought about it, and it's like, if we're doing all this work because we don't really trust the person on the other end to not use this information against us somehow, then maybe this isn't the right person to be getting into business with. So that's just an example that literally happened 3 hours ago with me. And so everything else that Mike has said too, in terms of the agreement challenges and the kinds of inconsistencies, etc., those are the things that we can help guide you through. But even if without a lawyer, if you're just going through like a step-by-step process on your own, it's just about having the kind of patience and having a process around trying to do a deal that will bring you somewhere where you do have some clarity.
Yeah, because again, too, the music industry, like law also, it's an industry based on relationships. So these are often people that you're going to be forming a long-term relationship with, whether it's your manager, a producer that you might record with a number of times. So these aren't things that you want to kind of just jump into. You want to make sure that they're the right people that you're going to be working with, in all likelihood, probably for a decent amount of time. So again, it's just about the due diligence with these kinds of matters. So the first type of agreement we're going to be talking about, it's more simple compared to some of the ones we're going to touch upon a bit later. And so this is the Cowriter Agreement, which is really just figuring out the division between the writing of songs and figuring out, this will kind of play into kind of some of the agreements later on, but it's dividing the composition of the song based on who's written it. And as with most agreements, the earlier you can do this, the better. It's never too late to kind of get this agreement in place later on. But again, if you're kind of writing with someone, it's never a bad thing to have a conversation about this. And this is often, the co-writer agreement will tie into a split sheet, which is here. And so this is kind of just a table that organizes the information for composing music. You can see that it'll have the proposed song name. It might be a working title. And then there's some of the credits, performed by. So it's the musician, written by, produced by. And so these are all things it's to protect yourself for later on should a dispute arise that maybe someone's claiming that they own the rights to a song that another person has written. And so this is just getting the pieces down in place early on, and to get a conversation rolling to kind of set out exactly who does have the rights to the composition royalties and just ownership of the song. And again, here,
Just to jump to
yeah.
Oh, sorry, Michael, sorry to jump in, but like, to our point about agreements and their enforceability and everything, split sheets are a form of agreement, really, because what you're doing is you're setting out who owns what and in what percentage. And even if there's no other details about it, you could look at a split. Even if it's the only agreement you have, it's an important one to get at the time, if at all possible. That way, it's never too late. But in this case, it's much better as early as possible.
Yeah. And this ties into both copyright. So it sets out who actually owns the composition rights. And then it also ties into royalties as well, to figure out later on, should someone be owed royalties, you can kind of reflect back on this agreement to see what was agreed upon. And so here you can see that it's quite simple to fill out. You just set out who the writers are and what you might decide on what the percentage is. Often it'll just be, if there's two writers, that it'll be 50-50 split, but that can be negotiated or decided upon in a different way between the writers. Similarly, there's the PRO, which is the performing rights organizations, if I'm correct, Bert. For Canada, it's often it'll be SOCAN, and they will give you an IPI number, which is kind of your running number that identifies you as a songwriter, or it may be as a musician, and that kind of sticks with you and is part of your identity, just for dealing with royalties management and kind of the business side of being a musician. So you can see again that it's a fairly simple table that just warrants a conversation with your co-writer or the other people in the room to figure this out as you're kind of composing and writing your music.
Okay, so producer agreements, what is their role? Now, essentially, it sets out what the producer is going to do for an artist with respect to the track. And it also sets out what what rights the artist ends up getting with it, but also the monetary side of what the producer gets out of it. And I don't know if we go into this in greater detail later, Michael, but the splits are usually the producer gets a portion, especially if it's a major label deal, they get a portion of what the artist would have made. So if the artist royalty is, for sake of argument, 15% of and my colleague Byron hates this term PPD, which is price paid by the dealer, because it's kind of archaic, but it's still used, which is basically the wholesale price of either the stream or still the sale of a CD. If that's 15% that the artist gets, then typically a producer would get a couple of points, 1 or 2 points, meaning that they would get 1 or 2 percentage points of what the artist would have gotten, reducing it by that amount. So if they get 2 points, then the artist would end up with 13 points. And sometimes there's an advance against what those royalties would be, and it basically ends up being recouped, and then there's no more payable until the advance is recouped on those. It also goes into things like the deliverables and the recording schedule. So these are the things that are in most independent contractor agreements around music or film or television or anything. It's like, when is production actually happening? What's the schedule for it? What is being delivered? And then what are the exact services that are being delivered as well? Is it just production? Is mixing and or mastering being included in all of this? So that's what producer agreements speak to. So, and I kind of went into a bit of this beforehand, but the conversation should be more than what amount of cash is switching hands. You have to pay attention to, if as a producer, when is it being paid? Is it being paid on delivery or acceptance? So often you would want, as a producer, to be paid on delivery, because you've delivered that thing, and you want to get paid for it. If it's on acceptance, then whoever you're delivering it to can make some sort of stink about what it is that you've delivered to them. So typically there are delivery requirements, and depending on your relative leverage as a participant in this, you can either make their approval rights limited to aspects regarding the technical and some commercial aspects of it, or it could be more onerous if the artist is more powerful in this situation, in which case, like, you got to watch out for that, because they can make you do a number of iterations for it, and then effectively reducing the amount of money that you're getting paid per hour for this thing, because you're spending a lot more hours on it. You want to make sure that it's clear as to whether tax is included, or it's something additional. And again, we talked about the fees being considered in advance. And just to break that down again, it's like, as a producer, you would want it to be a fee. meaning structured as a fee, meaning they pay you the money, and then if there's any sort of royalty that flows out of that, you're basically getting paid from spin one or dollar one off of it. That's typically not the case. It's more of an either or situation. So if you get paid a fee, it's considered a work made in the course of employment, or it's been assigned over to whoever you're delivering it to. You get your money. There's basically no downside risk for you or down the road, because you're in pocket all the money you would have made. And if the track is a bomb, it doesn't matter. You're still in your money. If it's an advance, typically you're going to get a bit of a smaller advance than you would if it were a fee, but you have the upside that if the track is a hit, what's recouping the advance is royalties. So, if you're paying, let's say, $3,000-4,000 a track, and somebody is getting 2 points of the artist's royalty on that, that's going to take a long time to recoup, unless it's a massive hit and it's getting streams all over the place. So it's kind of a mix and match, but the best of both worlds would be to have some of it attributed to being a fee, which means you just keep that and there's no recoupment, and some of it as an advance, so that you can participate in back end royalties if the track is a big success, and you get to be part of that success. So what percentage, if any, is the producer entitled to the song's copyright as the artist or the co-author? So the answer is it's going to depend on what it says in the producer agreement. What's typical, and if you have a producer that is a sought after producer, that may just be their terms, is that they get some portion of like the underlying song copyright. And in a lot of cases, that I feel like that's fair. That's just because of the additions that they've made to the song. They're providing an arrangement, and they're providing work that extends beyond just the recording part of it. If somebody makes a good beat, then that's as helpful in making a hit as any part of the song. So to get into these points here, though, the artist will want to producer to pre-approve as much as possible and give control to the artist, and the producer will want to ensure that they're compensated appropriately if they don't have control moving forward.
And that kind of ties into the previous conversation too about the co-writing agreement and the song split, because often you see now where producers will kind of take writing credits, especially in like hip hop, like you say, that often a producer will write the beat, or with pop music, they often have a hands-on kind of role with writing some of the music that's played.
Agreed. Okay. So, what are the scope of royalties that a producer is going to be earning their royalties on? So it could be on streaming, downloading, master use fees, meaning placements in film, television, commercials. Back in the day, they used to make compilation CDs as well, which was another source of master use licensing. The owner share of digital performance royalties. So things like in Canada, tariff royalties via resound, or in the States, it would be sound exchange. So how are royalties calculated? Is it a share of profits, or is it a percentage of PPD plus points? Because there are a couple of ways to do this. And as I mentioned, in a major record label deal, you're almost always going to see a percentage of PPD and points for the producer. If it's an indie deal, it's a share of profits. So to recap again, look, if they get 3 points, it's versus 3% of profit. They're separate sort of ideas, just in terms of the way that the accounting ends up happening. And one is more fixed, and one is just like take all the money that's been spent on the recording, deduct all the costs, and whatever's left over, that producer would end up getting 3% of the profit. So, and just in terms of record one, pay after certain expenses are recouped. That's kind of what I was talking about with respect to, deals that are more of a share of profit type of thing. What expenses are we talking about here when we're talking about the deductions? Is it marketing, manufacturing, other production costs? And that's kind of the difference between independent record label deals versus major label deals, is that the major record label will bear a lot of the costs in doing these things, so they spend a ton of money on marketing, or apparently they do. It depends on where you are and what priority they give you, but really marketing funds are that's actually their responsibility typically in an artist recording deal or a license deal. Manufacturing, again, would be the label's responsibility if it's a major label deal. And, production costs typically form part of the advance that would end up being recouped, though not all of them. Whereas if you're doing an indie deal, what ends up happening is kind of like I said before, take all the expenses, including marketing and manufacturing, and then whatever's left over from that gets split, or if it's a share of whatever that profit is. So, and the other thing you want to look at is how often are royalties reported and paid to the producers, and that's just like anybody. That's going to vary based on which kind of deal it is too. Artists are typically paid once every 6 months. After release, and then it's at least it's reported at that point, and then within about 45 days of the end of that period, they actually receive payment if there is any for them to receive. That could be more frequent if you're in an indie deal, only because the payment terms are a little bit more quick than that. It's typically sometimes it's month to month. It's more likely to be quarterly. So what is artist favorable? We will pay when we have the money to pay you, not to record one. And then producer favorable is the label pays the producer as soon as possible to record one. Okay, and so again, we sort of talked about this this give and take on whether you get more upfront or less upfront, and what the impact on the back end is. So generally, if it's a fee, you're getting paid more upfront, then essentially you as a producer, you're taking the least amount of risk. You've got your money in pocket, so an artist may expect you to not take any portion of the back end. Likewise, you may decide, I want to take risk on this. And so you get a smaller advance, and then it becomes, just a matter of whether or not the track is successful enough to make back that money. And then as you recoup your advance, maybe if it's a real hit, you have an opportunity to make more money than you would have ever gotten on a fee. So really, it's about how much risk are you willing to take on something, and often, like, it will really depend too. And producers have a feeling about things. They believe in projects, so they're doing things just because they have to pay the bills and they need the money. So if it's you will see different producers with different different arrangements. Letters of direction are basically a direction for a record company to pay you royalties directly. So, and that works in a lot of different cases, but in the case of a letter of direction, when you're talking about a producer, you would get a letter of direction from the artist, basically telling the record company that if for every for every time that they need to pay out royalties to you, they should pay the appropriate amount of royalties to the producer as well, so that the counting happens directly. In that way, it doesn't flow through the artist. And I'm not saying anything about artists, but I am saying about what I am talking about is when you have an entity, whether it's an artist or a person that's acting as an intermediary, and they're getting your money and then paying it on to you, there's always the potential that the money never reaches you, or less money than what you're entitled to reaches you. So it's always better to have a direct relationship between yourself and whoever's paying out. So just in terms of samples, that's something to consider as well. And in terms of the way that that ends up working, the grant of art rights to artist, what your remedies are, and also working with people that are outside of Ontario. So looking at your governing law as well.
So the next type of agreement that is quite common in the industry is the management agreement. So that's the agreement between the artist and their manager. When should they be prepared and signed? As always, it should be as early as possible. And that's just to get the basis and the construction of the relationship down and kind of cemented before you really get into work with them. And that's, again, as always, to prevent any issues down the line with like kind of just setting what the circumstances are and what the form of the relationship is. And so what the agreement might do is it might define what the day-to-day responsibilities are versus the bigger opportunities to come down the road, and how the manager kind of plays into those kind of working day activities, and then the opportunities further down the road. And as always, like we've been saying, it's all about the right fit. It's about doing your due diligence, understanding who the manager is that you might be signing with, and making sure that they're the right person to be doing business with as a musician or an artist.
Yeah, and to jump in there, in dealing with certain artists, like I've encountered where certain artists kind of have two managers. They have a day-to-day person, and they have another person that's out basically sourcing, what's here, bigger opportunities, and maybe they're negotiating the bigger record deals, or some of the other, and they're trying to find revenue for the artist as well through their connections, whereas a day-to-day manager is really somebody who's keeping an artist on track, making sure that they're showing up at their commitments, and is reading things on a day-to-day basis, maybe performance agreements they're looking at, but really they have somebody that's more of a heavy hitter, looking out for the bigger opportunities. And sometimes you see that within a management company where there's the big person that's out there doing that for you, and they have a day-to-day person that's assigned to you as well.
Yeah, and for both of these types of managers, if you looked at the agreements that are in place for them, they would actually look quite different, because there's different compensation coming in for these two managers, as well. There's different responsibilities, whether it's the day-to-day versus the more long-term roles. So that's kind of what these agreements are there for, is to set out all these different facets of the relationship and why it's important.
And a good point in that, again, like if you have these different types of people, if you look at the day-to-day type of person who's going to make their money, and I've seen that structured as a fee as well, or it's more like a fee on things, because they're with you every day, day in, day out. Maybe there's something for them if they happen to bring in an opportunity, but the other manager that's basically out there trying to develop business for you, they're more incentivized with a percentage of some sort of cut of whatever those opportunities might end up being. And that's the way that you end up. It's incentive for them, right, to keep them working. So good point.
Yeah. So as we've been kind of saying, what will you find in a management agreement? So some of the terms that you'll find in clauses, well, it will relate to the services. So what is the manager doing? What are the services that they are providing to the musician? So are the manager services exclusive? Often they won't be. Often you'll find that managers actually manage more than one artist at a time, which is quite normal to find in the industry. What are the specific tasks and authorities? So it might be approving publicity events or opportunities. It might be even executing agreements on behalf of the artist. So this is saying what does the manager do, and what are the responsibilities and tasks, and what do they have authority to handle on behalf of the musician, who is providing services. And so some of these kind of rights, these authorities might be found in approvals and powers of attorney. So these are kind of legal documents that'll say that the manager actually has the power to, for example, sign on behalf of one of the musicians or on behalf of the band or an artist, etc. So the term, so how long is this agreement in place for? What's the term or duration? It could be just 1 year, it could be 2 years, it can be anything that's agreed upon between the two parties. And there may also be clauses in place for ending the relationship early. So there's usually instances that I'll say if there's a breach of the agreement, then the non-breaching party has the opportunity or the right to terminate the agreement. In other ways, it might just say that the agreement will will start again at the end of the term if no one has kind of terminated prior to that. And so these are kind of normal types of provisions that you'll see in most agreements that kind of just set out the format and basis of the agreement and how the agreement itself exists.
If I could speak to just powers of attorney for a quick second, it's like you can have sort of tiers of powers of attorney. Like that, just an attorney basically means somebody that can act on your authority in your place. So someone with a power of attorney can do a lot of damage. So you have to have a very deep trusting relationship, and you'll have recourse against them. Like you can sue them, you can get punitive damages because they're considered what's called a fiduciary, meaning that they have a special duty to you to take care, use those powers for your benefit with the highest good faith. But what you want to do is you want to limit the situations to for the sake of convenience to where a manager can sign on your behalf. So, if it's a matter under a certain threshold of dollars, you might allow them to do that, where it's like if it's no more than $500 or it's in relation to booking hotels, that kind of stuff, like just convenience stuff. But for anything where you're obligated on a long-term basis, like let's say, a recording deal, a publishing deal, they can review it, but really at the end of the day, it ought to be the artist that actually signs it. Because too many times it can be abused, and sometimes it's not even abused intentionally, but there still has to be they still have to exercise that highest level of good faith. But in my view, it's better to just keep it to a minimum, because it is convenient to have somebody be able to sign on your behalf, but not on things that are really important or that require a long-term commitment.
Yeah, and that point kind of ties into an overall kind of mentality for when you're looking at services, is looking at what the authorities are versus the responsibilities. So what are they actually responsible to do, and what do they have authority to do? So often the manager, from their point of view, they'll want to have authority to do as much as possible, but actually have the responsibility to do as little as possible. And so it's kind of a balance game between those two things. And again, a lot of it just comes down to trust. Like, who is the manager? What are you entrusting them to do? What are you entrusting them to have the ability to do? And so all those kinds of items will be set out in services. And again, as mentioned, it'll look quite different for a day-to-day manager versus a long-term manager.
Well, and to that point too, Mike, in terms of the term, when you talk about a process to end your term early, that's typically based around some sort of performance requirement that somebody would place on a manager. You would say, well, I need to have earned X amount of dollars in the first year and another amount after that. And if you don't meet that, then I can terminate early. It doesn't mean that I have to. But the idea being, if I'm not really getting much out of it by having signed up, and management agreements are typically, and you'll probably talk about this, they're exclusive, meaning the artist can't go to another manager in the meantime, but managers can handle as many artists as they want to, and they may tell you, yeah, I only handle a certain number of artists, but it will be very difficult for an artist or a songwriter to get a term in their agreement saying X manager will only handle X number of artists at a time. So it's the imbalance is there, and that's why as an artist you want to make sure that you're getting something out of this too when this person is your manager. And managers can and do work very hard for their artists. It's just a question of sometimes something becomes easier, and like anybody, they get distracted and they have to arrange their priorities, and a lot of times, like people, they are arranging their priorities around what benefits them the most. So those are the things that you have to look out for, and that's maybe something that can be built into a process to end the term early.
Yeah, absolutely. So this kind of comes to it's a similar discussion to what Bert kind of talked about with the producer agreement with payment. So this is the compensation. So what exactly is the manager entitled to receive? What is the compensation for their services? So is it going to be a percentage of royalties or a consulting fee or a hybrid? So the percentage of royalties is it's self-explanatory. So it would be an agreed upon percentage of any royalties that the artist ends up receiving. The consulting fee is more of like a salary. It's a payment that would be agreed upon, or it might be a hybrid of both. So it might be a set fee that the manager receives over time, in combination with percentage of royalties that will come in. Usually, I think it's at quarter marks or biannual. Bert?
Yes.
Yeah.
I think it's it can be either. Typically, it's quarters, though, just based on what I've seen, only because you want to keep the artist in. It's more frequent cash flow, and so it gets reconciled more frequently. I now obviously there's going to be certain payments that are paid to the artist, and they're only going to be, sometimes once a year. I think, under a recording agreement, you're typically paid once every 6 months. So that's when they can expect to get paid. But on all other amounts, you'd typically be talking quarterly. I don't know if it's any more frequent than that. And I haven't seen an agreement where it's more frequent than that, but.
Right. Yeah. And so then the question is does the manager earn on everything? So is that on all activities that the artist takes on? So that could be things that are outside of actual music. So a lot of artists these days have other ventures, whether it's acting or engagements, publicity things. So what exactly will the manager earn on? And so that will be defined in the agreement. Similarly, there's the commission may vary. So these are all different facets of the compensation, and just defining what exactly the manager will earn on, because this just sets the relationship so that there's no. It's in order to prevent disputes and troubles further down the road. So this is what can be relied upon by both parties to understand the system that's in place for the manager. Similarly, there might be expenses and loans. So the manager might have expenses of their own. So this will set out whether they can be reimbursed from the artist. Bert, do you want to touch upon the sunset clause?
Sure. I wanted to back up a quick second on
Mm-hmm.
what's excluded and included in different management agreements,
Mm-hmm.
and just use an example where at one point the label I was working for was signing an artist that had an existing acting career, and of course we proffered an agreement that basically said, we take a portion of your net receipts from acting. And the lawyer on the other side, quite well, it was actually, even the artist was a very astute artist, and anyway, I won't mention that person's name, but they were very deeply into the business side of this stuff. So the person set out that they had this acting career, it was ongoing beforehand, and that we had nothing to do with the success in it. So why should they pay anything away to us for that reason? And that made sense. Like I was able to sell that internally, that we really shouldn't take any part of that. If there's stuff relating to the music career, like let's say this artist makes a musical appearance after we've blown our brains out promoting them, then that can be included. But their appearance on this particular Canadian television show that they've been a regular on for years, like we will just exclude that. And so that makes sense. But often it's like the more, well, it's also becoming more difficult to figure out where the line is drawn, because often labels are signing artists that have an online following, that have created content. Maybe they're doing something that's in the acting world as well, but it all sort of blends together. So parsing out, there's also the effect that because you make somebody famous as a musical artist, people get interested in the stuff that they were doing as an actor, and maybe they go back and there's a bump in their catalog on acting, and it does help their acting career, even though it may have nothing to do with music per se, even though it does have to do with how much promotion is going into that artist by the record label. So it's those are points of negotiation, and they do get negotiated. And sometimes it's like it's too hard to sort out, so you either say, okay, we're out of that, or you say we're in it, but we're in it for a lower percentage. And that's how it's resolved, because you're never going to be able to, it's a reasonable estimate of what spills into what bucket. And then on sunset clauses, which I'll pick up on, in terms of reasonability, again, I think, like a bit of an emerging theme, it's like, what is reasonable here? Sometimes you'll see it where, if they helped you to secure something that is ongoing, in terms of, let's say you have a track that gets used as the theme song for a television show. And it gets used for 3 or 4 seasons after the television. I'm sorry, your agreement, the term of your agreement with the manager comes to an end. Well, they'll want to say, well, we helped you get that, so we should be able to commission that as long as that source of revenue is still there. But again, maybe with sunset clauses, what you're trying to do as an artist is, limit the amount of time after, and maybe that's the analogy. It's the sunset, right? So the sun has set now, and how long is their light still lingering on? In which, which is, I guess, analogous to money that the manager ends up receiving. So
Yeah,
you want to limit.
Maybe you can explain briefly what exactly a sunset clause is.
Oh, okay. I'm sorry if we glossed over that. A sunset clause is basically upon the termination, so the end of the term with your manager. It means that there is a period of time, like the setting sun, where the manager is still entitled to certain amounts of money, their commission on certain things that you've done that are ongoing, or maybe happen shortly after. Like, if a manager has been working on a deal for you, and it gets closed 4 days after your term is up with them, you can bet they will feel pretty cheated out of that money, or that it was very unfortunate that they've done a lot of work in order to secure that money for you. So they're trying to secure themselves some money, so that you don't, if things are bad at the end of that agreement, you're just not just having the ability to terminate and not pay them for all of their work, because that's how they get paid. So that's really the effect of a sunset clause, is just to have a period of time after which there's still royalties that accrue to the manager. And so so those questions right there: what's reasonable, what's the scope regarding music and agreements, and what's the percentage? Again, another emerging theme here is leverage. If you have a manager that is big time and is going to get you a lot of, is sought after as a manager. There are a lot of people that want them taken on, and they end up managing the careers of their artists extremely well. Then the kinds of things like sunset clauses that they can ask for, at the length of them, the amount of whatever share of revenues they get after the term is over, they're going to have more leverage to be able to say, well, take it or leave it, and not really negotiate that.
So band agreements, these are things that are almost always recommended to do, but are not often found within bands. So, like the other agreements we've been talking about, this just really defines the relationship between the band members. It sets the responsibility of the band members. So there might be different duties and responsibilities divided between the artists and the musicians. There might be decision making powers that perhaps there's two founding members and there's new members that have come into the band in later years. So this will kind of set the roles in place and who has what authority within the band. It may be that the founding members have the Trump decision making power, for example. It also set the compensation. So again, this kind of will often tie into the co-writing agreement and the split sheet of who exactly wrote the songs, and thereby who will receive the money from the compositions and the royalties and performance royalties and all of that. It will have the band assets. So who owns assets with the band? Often bands will become incorporated now. So this will set out, it may be the corporation owns most of the assets. And if not, then, for example, who owns the band name or the logo and other trademarks that the band may have, merchandise and things like that, t-shirts, anything like that. So who really owns these assets that are in the band's control? As mentioned, it will set out the relationship between new and former members in relation to all the points that are listed above. So if there's new members that have come in place and the band has been around for 20 years, and so obviously the new members will not be entitled to the songs that came before them if they had a greatest hits compilation, things like that. So it just sets out all the terms between the members. And similarly, for the members that have left, or if the band itself dissolves, how does that take place? How are things divided? How are royalties divided in future if the band no longer exists? For there's bands that may return in other forms. So how does that all play in? Where, let's say, there's a break off band, are they entitled to play songs from the previous band? Things like that. So all of these will be set out in the band agreement. I think you're on mute, Bert.
One sec. Sorry about that. I've heard that many times in the last 18 months. So you may have touched upon it too, Mike, but so new and former members, and sort of baked into that is, how do you fire a member of a band? Because that happens too. And I've been involved in one of those sort of tangentially, and it's not pretty. And if it's not clear how those things happen in the agreement, because you formed a company here, it's almost like a little shareholders agreement. And so it's like, how are we going to run the company? How do we get rid of somebody who's part owner of a company? It's a lot of these things are those kinds of considerations. And so anyway, there's that. There's also, like, maybe you put some limitations on when like, you see this happen all the time. Like, I tell this story. I was running the Mississauga half marathon as one of the slowest participants there. But one of the bands that was there, they had a song called Soul City that was a hit of theirs. It was the Partland Brothers. And so their big hit was, the lyric was, "We won't come back until the money's all gone." And as I was running by, I'm like, and they're playing the Mississauga marathon, I just thought, well, I guess the money's all gone. But that being said, you see bands get back on the road when, if they've dissolved or whatever, they get back on the road when it's opportune for them to do so. So what are the conditions that allowed that to happen? And I've seen a band agreement where it was like, if it might be a 6 member band, but if the 2 founding members aren't part of it, then they can't do it. And so I know, there's one band that I'm thinking of in particular that had a following. They weren't massive or anything, but people knew their songs. And because one of the 2 founding members just didn't want to start things up again, even though there was an appetite for their music, there was nothing they could do about it. So that's just kind of the way it goes.
Yeah, and you see it all the time too with some of the massive bands that have been around forever. For example, something as simple as like Paul McCartney being able to play Beatles songs. Like, what
Right.
gives him the right to do that? It would come from somewhere. So that could be a band agreement or the co-writing agreement as the actual composer of the songs. So this will often come from agreements that were set. Or there's the Guess Who from Winnipeg. There's Burton Cummings and Randy Bachman. They broke up years ago, and they've kind of carried on careers of their own in different directions. So who's the right to play which songs? What can they be called? Can they be called the Guess Who? Or do they have to change their name? Things like that. So you see it actually quite often, and you kind of just have to reflect on it and think about, where do these rights come from? And this wasn't mentioned, but it's kind of, again, the theme. When should this take place? Well, as early as you can kind of have this conversation with the rest of the band. And oftentimes the band will be friends or family members. So you might think that this isn't needed, or it might be awkward, or it might cause uh, cause rifts, but it's just something to protect yourselves and to also plan for success. So that's really the theme for today, or those 2 facets of all of these agreements. And it's just a conversation to have casually, and you just propose it as something that's to the benefit of everyone, should you succeed or not succeed as a band.
Right. Oh, and in a who owns the name kind of thing, it's like at one point I remember, no one owned the name in this one band, and it was actually, I won't name the record company, but the record company owned the band name, which was, it was a weird thing. They owned it. What they did was they applied for the trademark, and because they owned the trademark, when the band sort of served their notice that they didn't yet they didn't want to record for them anymore, and it was, in a way that was maybe contrary to what was in the agreement that they had. The record company said, okay, that's fine, but we got to resolve all this stuff with the name, etc. And so that was a major leverage point in that particular discussion. It's like, if you don't have your name, what are you going forward? It's like, that's what you've completely built up. And there are bands that have overcome that, but mostly not.
Yeah.
I mean, to your point, the Guess Who have had like 3 iterations with three separate names, and the rights are owned by different people. So, it's different. It ends up being different, and it's a definite impediment to going back on the road and just having all that goodwill that is around the name.
Yeah. Yeah. Definitely.
Okay, so online performance agreement. And this has been, a bigger thing that's happened during COVID. They were obviously, there were online performance agreements before COVID hit, but it became very, as soon as it did hit, especially in April and May of 2020, everybody was doing online performances. And then I think there was a lot of online performance fatigue. But, they'll continue to be a thing, only because I think people are habituated to them now. And even if they're a bit fatigued, you're going to see them going forward more than you did pre-COVID, I would say. So factors to consider for online concerts is that there are different revenue models. You have to consider how long the concert will be available online. And, a lot of this has to do with clearance as well, because if you're trying to clear something to be online in perpetuity, worldwide, you start widening the ambit of rights that you have in terms of this song and how long it stays on. That starts becoming an expensive proposition if you don't own the rights in that particular song. And there are lots of bands that cover other people's work, or they're co-writes, and they need some sort of, and the co-writer isn't in the band, or is, it's not the artist. So those are things to consider. Whether the performance will be pre-recorded is something to consider as well, and that's a practical thing. Geofencing I spoke about, which is, if you start looking at the territory that it's in, is that going to cost you more money to get the rights for that particular song, right? And there are artists too that want to control, and managers, and rightly too, they want to control what's out there with their artist, right? So if somebody does an online performance and it's out there, and it's either not that favorable a performance, or it portrays the artist in a way that they've evolved from. And I don't even mean anything that's like, scandalous. It's just they've got a new sort of frame of mind. They're trying to portray something a little bit different. Managers are all about trying to curate that. And so if they see something out there that they don't like and they think is inconsistent with the new brand of the artist, they're going to want the control to be able to say, hey, you need to take that down. So often that's why um, you will see controls on how long something is online for, because they just don't want to see things getting stale dated that are out there. And also it's an opportunity for, let's say it's hugely popular too, and it doesn't really lose any of its luster. Well, that's just another opportunity to negotiate another fee for an extension of time on that. Radius clause, and I think this is in relation to probably more to do with how it interacts with live gigging versus online gigging. But is doing an online concert going to cause some sort of dip in an actual concert? And there's some belief that you wouldn't televise a big concert necessarily, for fear of reducing the audience at the concert. So that's something to consider. And then you have to take a look at the online platform or tool being used to watch the concert. And that's very true in terms of, so there are platforms that have done deals with music publishers, and there are platforms that have not done deals with music publishers. And so, and depending on whether something ends up, is eligible for monetization or not, you have to take a look at that. YouTube is pretty. They have pretty robust deals with the record, rather with the publishers, that allows them to stream these sorts of things. But if there's monetization and it's a big enough concert, then you have to watch for that too, because it may fall outside of what YouTube's deal is with the publisher.
Right. And before we go to the next slide, I'll just briefly mention, as we're kind of getting towards the end of our presentation, that there's a chat function, I believe, and if anyone has questions about anything we've been talking about, we can kind of try to address them as we're able to before we finish tonight. So I'll be taking a look in the chat while we get towards the end. As well, I see that Ashley has provided links to a number of the blogs that our firm has written that kind of tie into a lot of the topics we've talked about tonight. So yes. This is a little segue to the next topic. So next we've
no refreshments, but that's okay. I mean,
yeah, exactly. Yeah. Yeah, there you go.
Okay, record label agreements. So you as an artist, you have to think about, what are you giving up in terms of doing this, or what are you giving? So a big part of this is, like, if you think about it, the money is important, but really the thing that takes up a huge swath of an artist's life or could potentially, is the length of the initial term and the option periods, and how many option periods there are. Because if you think of it that way, it's like, if you have 4 option periods, and that's pretty standard in a lot of major label agreements. And if you think that, and my colleague Byron made the point that the last time that we talked about this, it's like option periods are typically to deliver another album. and it is no longer an album world. It is definitely a singles world. So you may deliver if 12, 13 singles over the course of 4 years, and you've maybe, if there's no language in the agreement that says, hey, if I deliver 12 singles to you, that is going to count as an album that basically fulfills the delivery requirements of that first option, then you're stuck in that agreement. So this is like an important reason why you do need a lawyer to look at it with a careful eye, just to make sure that, especially on stuff like that, because the length of time that can be involved is is very, very long. And that would be somewhere where you can focus your energy on negotiating less option periods potentially too. And the reason that a record label would want more option periods is because they're taking it's an investment, in bringing an artist and breaking an artist is an investment of time, and it doesn't happen in the first while. And if we're talking about the old world, it's like, album one is often not the greatest. You're pretty in terms of sales, right? Maybe it's a fantastic maybe it's a fantastic pop album, but in terms of sales, it, for whatever reason, it just didn't sell. But the A&R people see that, hey, listen, we still have a lot of belief in this artist, and we want to keep going, and we have the option, so we'll exercise the option. And the options cost too. It's not like it costs the record company nothing for them to exercise the option. They have to pay another option advance, and then there's a recording fee typically associated with that too. So they're basically saying we're taking another chance on this artist, and then maybe option two the option album two sees more success, and then by option album three, it's really humming. and and there was a lot of buildup and investment that the record company, they're really beyond making even, but they're on the cusp of making some real profit with an artist, and the artist is going to make profit too. Well, if they only have, you know, if they only have the three albums, that the three options, then they built up this artist for somebody else to reap the rewards from. And that's fine. A lot of times what will happen is an artist will not be happy with their deal or the amount of options initially. And if they have a lot of success, then that artist has a lot of leverage again to say, hey, I'm not happy with this. I'm not happy with the economics of this deal. I don't like my royalty rate. I think that I need a higher advance here, and I don't like giving you guys 10% of ancillaries and merch and everything like that. I want to claw it back to 5. And these are all just examples. But if you have an artist with a lot of success, they can start futzing with these, and record companies will listen. They'll do it because they have the leverage to say it.
So Bert,
But yes.
I'm sure you'll touch on this in a second, but when you're looking at like an agreement with a record label, like what exactly does a record label provide as in terms of like services to an artist?
Yeah. So the main things that they provide, and the thing that the artist is going to feel the most, is they provide A&R services. So you have some great artists and repertoire people in a lot of these labels that listen to the artist, help them develop, help them find songs, that really suit them if they're not necessarily a singer-songwriter. And if they are a singer-songwriter, they're going to get them into they're going to find good co-writers, like co-writers that maybe an artist wouldn't be able to get on their own. And that's all about and then the other thing that they provide that is the reason that they're able to that they have access to better songwriters, to people to help them develop, is because um, they spend a lot of money on marketing, and that mainly it's the marketing machine that a record label provides. They provide sales, they do distribution, all these things that are sort of implicit in being a record label. But really, at the end of the day, what they do is they help create the artist as a commercial art, and basically put it out there and market it and try to connect with people, or bring the music to people that it would connect with. So that's what you get when you sign and that's what you should be getting when you sign a record label deal. Now, and again, to your point that you made earlier about having all kinds of powers in it and no obligations, like you got to make sure that a record label is going to tell you a bunch of things, and they may not be wrong or lying about it, but those are things that you're going to want to see in the agreement spelled out, especially a marketing commitment, spends around releases and your career, tour support money, because tour support is really the way that you market yourself in a lot of ways, and so it's touring, and then what kind of support are they going to do in terms of socials, etc., and having people that work you. And a lot of times, when you're getting signed to a major label these days, it's not complete unknowns with a bunch of songs that are coming into the record label. It's like an artist has built an audience, so their marketing department takes a look at it. The other thing that you get that's great from record labels these days too, and they're getting better at it, is data and metrics. Right? They're going to use the data to market you and put you in front of the people that are most likely going to want to hear you. And in a way that hopefully isn't completely obtrusive or distasteful, right? Hopefully they do it in a way that it's natural. It just feels sort of intuitive, like, oh, this was suggested to me, like whether it's Spotify algorithm, or there's some sort of, if not influencer, somebody who's in a community that's saying, check this out, because we're a bunch of like-minded people in this group, so I have a strong hunch that you will like this, and those people have an awful lot of influence. And but marketing and data is about finding out where those conversations are happening too. So those are things that record labels are good at, or are getting good at. you know um, and so, yeah, just to wrap all of that up, they also give you an advance to record the tracks, which is not nothing. And I don't want to sound like I'm touting major record labels here, because a lot of times they make some of these promises, they give you an advance, and there are a bunch of stories where, because for whatever reason, it's just like they switch gears. You get a new A&R person running the show that doesn't believe in the direction of your music, decides to take another direction, so your thing gets shelved. Or in the US, what I've heard about happening at particular times is there's another artist on a label, on the same label, or in the same group, that's competing with you because you guys are a lot alike, so they have to put their money on one or the other, and you aren't chosen, and they shelve you. And I've also heard of stories way back in the day, and not sure if these are true or not, but it's almost like they acquire an act because they don't want it to be competitive, and that's very nefarious, and I haven't heard about that lately. But I also just want it known that, um, you know record labels, if you look at them for what they really can provide, and you hold their feet to the fire on that one, on what it is that they're telling you, over beers, and when they're trying to woo you, um, then they're useful. They're useful to you. It can be a very good relationship. So the advance is another thing that I'd like to go into a little bit about. um, I've heard lawyers and people in the business sometimes call an advance a loan, or liken it to a bank loan. And I've even heard lawyers say to me, like, this was during a negotiation for a label deal, where they said, well, yeah, my client could just as easily get a loan. They've got, they've got a lot of success and things. And I'm like, sure, yeah, they could get a bank loan, but then they could also have a payment schedule that they have to keep, or they're in breach of their loan agreement. And that's not how advances work with record labels, or even with publishers to a degree as well. There's not. It's more about, they put this money out there, as they pay you in advance. It's an advance on royalties from sales or consumption of your music. They recoup that from sales. You don't have to, during the term of the agreement, you're typically not under no obligation to pay it back, and often these deals will just extend until they recoup. Meaning, if the record keeps earning money, eventually they'll get paid back. Most advances are never recouped, as on the artist side anyway, because the economics just aren't there. And you have to have a real success in order to recoup your advance. That's kind of the way it ends up going. But nobody's calling in a loan, nobody's collateralizing it against your car or your house, which is what banks do when they take out a loan. So it's more of a, hey, we're going to invest in you, artist, idea, and that's the way it's pitched, and I think that's real. As opposed to, you've got to pay us back with interest, and they're not in the business of loaning money for the sake of doing that, because there are way surer ways to take your money and make money. Maybe the upside is bigger if you have an artist. You can get a bigger upside on that, but your downside on, if basically you're breaking 1 in 10 artists that you sign, that's a low success rate that I think a bank would stay away from. So and so all of that, we talked about the release. A release commitment we did not talk about. We did talk about a marketing commitment, though, and that's something that you want to get in writing. I'm gonna turn that off.
I think he should be back in just a second.
Yeah, sorry, my apologies. That was a telemarketer.
Classic.
Classic, exactly. So marketing commitments, great if you can get that into an agreement. Release commitments too. That's another thing. You want to make absolutely certain that what you deliver is going to be released in the way that and they're not just going to shelve it, right? So it's a time limit from the time that you've delivered the album, that they end up having to release it. And then, if they have and most record label deals will have the record worldwide, it's like you need release commitments in outside of just Canada, right? So, and that's typically what you're looking for if you're doing it in Canada, is a release in the U.S. and maybe some other major markets like Germany, the U.K., Australia. Those are like sort of the top 5, and maybe Japan as well. But it's easier. You want it to be meaningful release as well. So, like when we talk about release and marketing, it's like it's so easy for anybody to just put up a track and flip a switch and it goes live all around the world. And if your release commitment provision isn't drafted correctly, then they've fulfilled their obligation and basically not really done anything for you in these other countries. You want something meaningful. You want some sort of promotion and some sort of spend around it too. And potentially, like with the US, you don't want that going through necessarily like a distributor. You want it on an actual a record label that has a marketing force and is an imprint, because those are the people that will get behind it and do it for you. I mean, the holy grail is to get a released on a US based label. And I know that a lot of efforts have been made in the last while to make Canada somewhere from where artists can break internationally, and it's happened the odd time. It's just not necessarily as likely. And so, if you're signing with a Canadian subsidiary of a major label, you're going to want release commitments and some sort of U.S. commitment in terms of it being pushed. Okay, so the fun stuff, accounting and audits. You want to find out when you're going to get reported to and paid, and so that they have obligations to do that. Typically, as I said, in record label agreements, it's like once every 6 months, and that just has to do with sales. It may be getting accelerated as a result of digital now too, because they're getting reported to. The record labels are getting reported to more frequently by the DSPs, the services like Spotify and Apple Music, the different streaming services. I think the 6-month accounting came from a time where There were a lot of physical copies of things going into bricks and mortar stores. They would get sold, typically most of them right before Christmas time. And then in the new year, there would be a lot of returns. So people would return stuff, and then the record label would have to refund money to the brick and mortar stores that had that paid it up to 20%. So what that accounting period was trying to accomplish was to basically allow for all of that to happen. So if somebody gets paid within 30 days of at the end of January, then any returns would be sort of applied and taken care of. And if they had to refund money, you don't get paid on money that ended up having to be refunded or returned. So that's what that was for. So the accounting can be more accelerated these days, or at least that's an area to push on. It looks like we have a question. Which maybe we'll take care of the question at the end because it has more to do with publishing. And so audits are another piece of this too, and audits should be in both publishing agreements and really any agreements where somebody's handling money on your behalf and paying you out, and it's on the basis of sales, exploitation, consumption, whatever it is. You want to be able to go and examine the books of that company as they relate to you. It's limited to what you would earn as an artist, and they can go through them. And if there are things that they haven't reported, then you should get paid on those things as well. And so, like your typical audit provision provides that somebody can go and examine their books in relation to the artist's activity for up to 2 years from the time that they've delivered a statement to you. So you have a couple of years. Sometimes it's less than that, but the idea is that accounting tends to happen more accurately when somebody goes in and makes sure that it's happening accurately. So reps and warranties in terms of record label agreements, there's all kind that that's very legalistic kinds of stuff, but a lot of that has to do with originality and the kinds of things that you're going to deliver, and you make sure that what you do end up delivering doesn't put the record label in a position where they end up getting sued because they're either putting something out there that defames somebody, or is copyright infringement, or infringes some other intellectual property right. I'm trying to think of what other kinds of reps and warranties would typically be in there. You know them when you see them, but really it's about, and you want to have representations and warranties from the record label too, which will likely be more, a little bit more basic, like they have the authority to enter into the agreement. There's all those sorts of things, and maybe Michael, you can think of some things too that I'm not that aren't twigging me right now, but like that's the part where you have to really dig in and make sure that what you're representing and warranting is something that you can actually provide. So, you put in a lot of qualifiers too, because if there are certain things you're asking you to represent, like you just need to make sure that, like you've either done your diligence and or you qualify the language that's in there to say that, to the best of your knowledge, this is the case. And in terms of breaching the agreement as well, like these are, the breaching an agreement when you're an artist comes down to a few things. The main one is late and non-delivery of deliverables, which are the albums and the tracks that you're supposed to be delivering to the record company. And sometimes it comes down to approvals and not delivering what the kind of masters that it was that they asked you to deliver. But those are the kinds of things that you look at, and when you look at that, you have to look at it with a pragmatic eye when you're an artist lawyer too, because you have to make sure that they're giving you ample time to do what it is you need to do in order to make the tracks that are going to be delivered under the agreement. There's there's a documentary, and I don't know where it is right now, but it's about 30 seconds to Mars, and when they actually got sued by EMI for non-delivery of an album. And a lot of that was around their dissatisfaction with what it was that they were going to be delivering. They thought they were being pushed too hard, and so they were making a film about, just the band. And the film turned into, it's called Artifact, if I remember correctly, but it was about them being sued by EMI, which, made for a fascinating story for sure. But it
I
happens.
know that sounds actually quite interesting.
Yeah. Yeah, I was there at the time. It's also something that a record company doesn't want to do. Like,
Mhm.
they're sort of at their wits end if they feel like they have to sue an artist, because it's not a good look. You do, as a record label, if you're suing your artists, what is that saying to artists that you're trying to woo and come to you? It's saying, hey, if you don't do what you're supposed to, we really are going to sue you. So it's that you're no longer on the first date stage there anymore. It's like that's a divorce. So that's kind of what breaching of an agreement and terminating agreements are too. And there are breaches that the record label can make too, like, they don't pay their advances in a timely manner. There's always a provision for cure on these things too, meaning that there's a certain period of time. If they haven't delivered something, if they haven't paid you, you haven't delivered something, there's typically a provision that says you notify the other party of the fact that they did breach the agreement, and then they have a period of time in which to cure it, meaning they deliver what they were supposed to deliver in that time. So if it's an advance payment, then they deliver the advance payment. If it's you delivering album 2, then it's you delivering album 2, and provided that you do it in that period of time, the agreement doesn't terminate. It just keeps going on as it was. But if you don't deliver it within that period of time, and you don't negotiate some sort of extension on that, then everybody's in breach, and or they can put you in breach, and they can end the agreement, and there could be damages that flow from that as well. And there you go. So did we now? I see that there's I know it's 7:59. Somebody's asked, Matt Zimmerman has asked, could we touch on publishing agreements between a songwriter and a publishing company? And sure, they are structured a lot like record label agreements, and typically they contain some sort of advance, and the advance is to be recouped on, whatever publishing royalties are earned by the and oh, that's great. Thank you very much for putting the blog. But I think, and that would be a great one to take a look at as well. But essentially, you earn back or you recoup the royalties for the publisher. They have A&R as well, like an artist and repertoire, that help people develop as songwriters. They go out and they help pitch songs for placement in commercials, etc. That should be in there. The split of revenue should be in there as well. But often, there's like sort of like an option in there as well, in that in order to trigger your next advance, you have to secure an agreement with a major record label in order to do that. So that's something to watch out for as well. But I would recommend reading through the very well written music publishing agreements blog that my colleague Byron Pascoe put together.
And that kind of takes us to the end of today's presentation. And really, our objective for today was to kind of just introduce you to some of the common agreements you'll come across as an artist. And what we would definitely recommend is never sign anything without understanding what exactly you're looking at. And there's a lot of resources out there that can help you. You can see our contact information there. If there's ever any follow-up questions, there's our blogs as well. And so we just wanted to introduce you to some of the agreements and some of the clauses and what they're meant to do and why they're important to know about them as a musician and artist.
Wow, that's a lot of information. Thank you so much for taking the time to go through all of that, because it's it is a lot of information, but it's all really important, and you don't need all of it right away. And I hope people can watch this and go back and watch the things that are immediately relevant to them. Maybe they're planning on recording, so the publishing agreement makes sense, or maybe they're looking for a manager and looking back and watching that part, and also maybe reviewing the links in this description. So like these videos and presentations have been really meant to be a resource. So everyone watching, don't, just because you watched it doesn't mean you have to go and rush and do everything now. You can come back to this. So thank you so much, Michael and Bert, for doing this. Really wonderful information, and you laid it out in a way that like makes sense. At least makes sense to me. And I hope everyone watching. So is there anything you'd like to kind of say to wrap up, or any last little tidbits that came to mind before we call it an evening?
How about you, Bert?
Oh, not for me, other than good luck to you all. And, hopefully if you're watching, you're creators, and, I wish you all the success in the world in that. That's, it's a noble thing to be doing. So get out there and create.
Absolutely. So thank you everyone for joining us. This is the final session of the On Track Indigenous Music Business Basics series. You can go to indigenousmusic.ca/ontrack for more information about the series and to watch the previous videos or presentations that we had. If you have any more questions about what we talked about today or anything music career related, you can email me at ashley@manitobamusic.com. I hope you have a wonderful evening, and I hope to see you next time, whenever that is. Marcy, and good night.